There are many who can read judgments, but very few can use them correctly. The reason is simple. They don't clearly understand which part of the citation matters and which part does not. As a result, they confidently cite irrelevant paragraphs. Seniors quietly remove those citations, and courts ignore large portions of what is placed before them. In this lesson, we will break down ratio, observations, and obiter, not academically, but practically, often how they are treated in court. Many people read judgments like stories. They highlight paragraphs that sound convincing. They quote lines that feel authoritative and paste extracts without the context. But when the court asks, is this the ratio of the case? Or is this the reason for deciding the case? The junior often hesitates. And let me tell you that hesitation is damaging because the court is not asking you whether that paragraph is good or not. Instead, it is asking whether that paragraph binds, guides, or can be ignored. That distinction matters. Ratio is not every line written in the judgment. It is also not every legal discussion present in the judgment, and also not every paragraph you highlighted. Ratio is the legal principle without which the decision could not have been reached. In simple terms, if you remove the ratio, the whole case collapses. But if you remove everything else, still the decision stands. And this is the reason why courts care about the ratio, because it gives consistency, it gives clarity, and it binds future judgments within the hierarchy. So, if you cite ratio correctly, the court listens. Observations are statements made by the court while explaining, while clarifying, or while reasoning beyond the strict necessity of the decision. Observations may be insightful, they may be persuasive, or even quoted by other courts, but they do not bind. People confuse between observations and ratio because they sound authoritative, they come from respected judges, or they appear in reported judgments. But courts treat observations carefully. An observation helps only if it aligns with the issue before the court or it supports, not replaces the ratio. Obiter are remarks, not necessary for decision making. Often they are hypothetical or sometimes forward looking. Obiters can influence future thinking. They can inspire legislative change or can guide academic debates. But in litigation, obiter have the weakest persuasive value. People misuse obiter because the language is strong, or the line sounds decisive, or it is made from a judge who is well known. But courts will often ignore obiters if the ratio does not support the argument or the issue is materially different. So, citing obiter as if it were binding is a serious mistake in litigation. From a courtroom perspective, the hierarchy between ratio, observation, and obiter is quite clear. Ratio is binding and have strong persuasive value. Observations have context dependent persuasive value, whereas obiter are the weakest one among all three. Judges may appreciate observations, whereas they rarely rely on obiter unless nothing else exists. So, if your argument is built on obiter without ratio or observation without application, it is structurally. weak. People mix ratio, observation, and obiter because law schools do not teach the applications of these three in detail. Databases do not label them clearly, and seniors often assume that juniors already know about them. So, people learn by trial in courts and under immense pressure. And this lesson exists in order to minimize that painful learning curve. Before using any paragraph from a judgment, read that paragraph carefully and ask yourself, is this the ratio? Is this necessary to decide the case? And will my case stand or fall on this principle? If the answer is no, then treat it cautiously. Let me give you a safety rule. If you cannot answer why a paragraph from a judgment is ratio in one single sentence, then never present it as binding law in court. This habit will single handedly improve your credibility, strengthen your submissions, and reduce embarrassment in court. So that's all for lesson 4. But once you understand what matters in a judgment, something else becomes clear. You don't need many cases. Instead, you need a right one. In the next lesson, we will discuss why one good judgment is better than 50 weak citations and how strategic restraint improves courtroom impact. Thank you.